back and presenting for us again today.
Marina, thank you very much for inviting me. I look forward to it. So I'm Mark Blumberg. I'm a charity lawyer in Toronto, and I'm going to be talking today about top charity compliance issues for Canadian registered charities, as well as some recent developments and information that you might find helpful. Just by way of background, I work at a law firm, a small firm in Toronto, and we have 5 lawyers that just work in the nonprofit and charity area. And if you're interested in the issues that we're going to be discussing today, we have 4 websites that might be of interest: Canadian Charity Law and Global Philanthropy.ca, which are dealing with essentially blogs with lots of information on the charity and nonprofit sectors in Canada. We also have smartgiving.ca, which is a website around selecting good charities. There's tons of good charities out there, but also just warning people about some of the problems with charity scams and things like that. And then we have a website called CharityData.ca, which is freely available. It has over 5 gigabytes of data on the 84,000 Canadian charities that are on there, going back 15 years in some cases, with information on them. It's much easier to use than the CRA database, which has much of the same content, but it allows you to do many things the CRA website doesn't allow you to do, including searching for directors, as well as noting which other charities gave money to a particular charity. So on the CRA database, it's easy to see when a charity gives money to another registered charity, but this allows you to know with a particular registered charity who gave them money in the different years. And if anyone's interested, we have a newsletter we send out occasionally with updates as to what's happening. You can sign up there. And also on Twitter at Canadian Charity if you're interested in following me there. So this is legal information, not legal advice, because I don't know all of the many groups that are on the line and what their particular situations are. The views expressed are my own, and if you have, as Marina said, questions, you can send them through, and we'll try to deal with some of them at the end. And we'll go for about an hour discussing top compliance issues as well as some recent developments. So just some basic information to start off with. Registered charities are regulated by the Charities Directorate of the Canada Revenue Agency. The Charities Directorate is a small department with about 250 people in it that is part of this much larger CRA. And it's I would argue, very different than the rest of CRA. It's focused on essentially registered charities, and it has a different way of operating and that sort of thing. Now, registered charities fall under both federal and provincial jurisdiction. So you know that if you fundraise and, for example, individuals give you over $25,000 in Alberta, you need to register in Alberta. Or if you're doing fundraising in Ontario, you should register with the public guardian and trustee in Ontario. But generally speaking, in Canada, most of the provinces and territories have not been very engaged in regulation, and there's not that much. Most of the regulation is under the Income Tax Act, with registered charities having to comply with rules relating to that. The good news is then you have, if we had all the provinces really engaged, you'd have 14 provinces and territories, or 13 of them, telling you what to do, plus CRA. That would be very burdensome. So I'm quite happy that we've sort of backed into this, maybe by mistake, but we have essentially one regulator. So even if you don't like what the CRA has to say, at least you know what the rules are, and it's quite easy to determine. And if you're a national charity operating in multiple jurisdictions, you don't have to worry about there being 7, different areas of law that are different that you have to take into account. Now, nonprofits and charities are both tax exempt. The big difference between a nonprofit and a charity, or a registered charity, is that the registered charity can issue official donation receipts, which gives huge income tax savings to a donor who gets one of these registered charity official donation receipts. And sort of bottom line, there are benefits of being a registered charity. There's also restrictions on being a registered charity. I don't tell people lightly, if you have a big operating nonprofit, to become a registered charity, because there are lots of downsides as well as some upsides. So I tell people, just be careful, because you need to sort of be aware that there are these rules, and one must comply with them. And to be a registered charity, there's sort of 3 pieces. One is you have to fit under at least one, although you can be under more or all of them, but at least one of the 4 heads of charity, which are relief of poverty, advancement of education, advancement of religion, and other purposes beneficial to the community in a way the law regards as charitable. which is certain areas like healthcare, the environment, volunteer fire departments, etc., that various court cases over the years have accepted as being charitable, or CRA has accepted as being charitable. So you have to fit within one of these things. Some groups, if you think of the Salvation Army, they may be doing all of them: relief of poverty, advancement of education, they could be doing healthcare, religion, etc. But you can't have any purposes that are outside those 4 areas. And if you have 10 purposes, they all have to be charitable. You can't have 9 that are charitable, so exclusively charitable. Then also there's this concept of public benefit. So it can't just be that you're doing something that's charitable. It also has to be for the public benefit. So if you wanted to set up a charity just to help your child with a particular issue, then that wouldn't be a sufficient public benefit, and it probably wouldn't be accepted by CRA. The third part is you have to apply to CRA and be accepted, and then you're on the CRA database, the charities listing, and you can check our information on any one of the what are currently about 86,000 registered charities on that charities listing, and that's the most up-to-date place to find out if something is a registered charity. And if you ever do need to contact CRA, here's basically some contact information. They've changed their website in the last bit to the Canada.ca website. You can get on their email list, although my one is better than theirs, but you can get it directly from them, certain information they provide. They send out emails every month or 2. Then they also occasionally do webinars if it's of interest. The main thing is for groups, if you have a question, in some cases they have an 800 number, you can call them. They tend to be very good at answering questions on certain topics, especially easy things that they get a lot of. If it's a more complicated type of issue, the response is often not going to be as helpful, and that's where you might want to look at getting legal advice in some cases if it's helpful. Also keep in mind that there's many different types of charities, and the answer legally, ethically, standards-wise, etc., for one group might actually be quite different for another group. So don't just look and see, oh, there's 10 groups doing something, therefore it's okay. First of all 10 groups may be doing things improperly, but secondly, it might be okay for them, but not for your organization. Objects of groups, for example, can be very different. If you have an object to help homeless people in Calgary, it means that you can only help homeless people in Calgary. You can't help homeless people in Edmonton, even though that would also be a wonderful thing to do. You need to then think about changing your object. If you're in certain areas of charitable work, like healthcare or daycares, there can be tremendous regulations of those areas that you need to be mindful of. Many groups are very risk averse, others are doing hard situations. So what one group would take on is very different perhaps than what another group would take on. The other thing is that public profile, if you're a very prominent charity, the community is often aware of what you're doing, you have to be even more careful to protect your reputation, etc. If you have a lot of major donors who have very significant demands, you need to keep up with it, as well as if you're getting government support. Very rarely is government giving money to charities without there being a 50-page agreement that requires lots of things that you need to comply with. Are you independent versus affiliated? If you're part of a group that has many chapters, there could be all sorts of additional requirements that apply to your group as opposed to another registered charity. In terms of resources, the average charity has a revenue of less than $100,000 a year. The average charity doesn't even have 1 employee. So a lot of small charities, but then a lot of also bigger charities. And we have, for example, about 20 charities that have revenue over $1 billion a year. So what is right for one group in terms of a policy or manual, for example, when it has 5,000 employees, may be completely inappropriate for another group that has 1 employee. And then the values of charities are very different. Even if you think churches that are Protestant, you could have very, very big differences between them. So understanding what is appropriate for your particular organization is really important. So now in terms of the top compliance issues, I'm going to start off with failure to file an accurate T3010, because this clearly is the #1 issue. Every year, about 800 Canadian charities are revoked because they do not file this one form. So that, just to give you an idea, for all the other shenanigans that goes on in the charity sector, from undue private benefits to terrorism to inappropriate receipting and all the other things we'll talk about, only 20 to 30 groups are revoked for cause every year, and 800 lose it because they just don't file this form. Unlike other countries where they give you 2 or 3 years, in Canada, you basically have a very little time to file it. After the 6 months after your fiscal period is over, then you have basically, they will allow you to be late 60 to 90 days, and then they will just automatically revoke you. So the moral of the story is you want to obviously get it in on time if you can, and you want to diarize the date. CRA is trying to put in place systems to remind groups as much as possible, but you really should try to make sure that you have systems in place to start preparing this form. For small organizations, you want to start preparing it 2 to 3 months after your fiscal year is over, so that you get it in, if possible, 5 months after your fiscal year end. Don't wait till the last week, if possible. But for a big organization, which is complicated, you have to start like 1.5 years before the form is due to start making sure you have systems to collect the information, etc. CRA will mail you labels, and the most important part is the back side of the labels, which have certain information on your charity that if it's not accurate, you should update it. And I mentioned the charity data website, but if you want to see an example of how T3010 information is important and can be used, take a look at charity data for your charity, and it'll give you an idea of some of the past historic filings for your charity and others. So why file the T3010? Well, it's legally required. It is the only uniform way to compare Canadian charities. So if you're looking at 200 charities, it's one way of comparing them. It is, when it's done well, an advertisement for your charity. It can provide information on what your charity is doing. It can show that your charity is a significant organization that has a lot of resources, etc., etc. When it's done poorly, it can send a different message, and many people don't know about the details of what you're doing as a charitable program. If you're doing mental health for children, they don't know whether you're doing a good job or not. But if they see problems on your T3010, if they see you putting things in the wrong place, it sends a message that is not the best message. And also, I tell people, it's not that a lot of people look at the T3010, but a lot of important people who can make decisions that can affect your organization look at the T3010. So that's government agencies who are thinking of funding you, who may just decide not to. That's a lawyer preparing a will with a bequest in it who sees something and it's a concern and discusses with the client, and you end up being dropped out of the will. So important that you get this form done well. It's part of this whole, we are not secret societies, we are entities that have been given very special privileges that are very beneficial, and we need to be transparent with the public about what we're doing. And for most groups, they've worked out that you need a lot more transparency than T3010, your websites, annual reports, newsletters, email lists, the sort of things that some groups are doing. But unless you do the T3010 well, that's really the first mandatory and the only mandatory compliance that you have to really do for most charities. So make sure you do that. If necessary, don't have an annual report. Rather put the effort into making sure your T3010 is really well done. Okay. The consequences for failing to file are pretty extreme. Revocation of charitable status within a matter of months. You won't be able to issue receipts. You lose other benefits of being a registered charity. There's property tax discounts. There's ability to easily get money from foundations. You lose all of that. And if you're not re-registered within a year, there could be a revocation tax that can basically take away all of the assets that your entity has. And for some organizations, especially older ones, it may not be so easy for you to be re-registered, or may not even be possible. It's not that charity today is narrower than what it was in 1967. I would say it's broader, but they're paying much closer attention, asking lots more questions than they did 50 years ago. In addition, there's a $500 penalty, but in the bigger picture, that is nothing in comparison to the other consequences. Now, mistakes with the T3010, because I said you should file it accurately, very important that you carefully look at the form, that you make sure that you are doing it as well as possible. If you're a complicated, big organization, it should not just be the CFO preparing this form. The finance is obviously involved, but it should also be people involved with governance. It should also be people involved with fundraising, with program activities, etc. You really want to have a number of people looking at this form to make sure that it accurately reflects the work that your organization is doing. CRA has a fillable T3010 that you can get online, and you can fill it out, and right now you can only print and mail these things in. As of November, and I'll mention it again later, it'll be possible to file electronically forms with the Canada Revenue Agency, which will help some groups do it easier, more efficiently. As a result of the 2012 federal budget, now if you file an incomplete, inaccurate T3010, CRA can suspend your ability to issue receipts for a year. And this is a tool they're really starting now to use, essentially suspensions and penalties, much more than revocation. So because revocation is sort of the death sentence, they're trying to use these what are called intermediate sanctions. But for many groups, if you were not able to issue receipts for a year, that would be very problematic. So just saying it's not good enough to get form A, you really need to make sure that you do it appropriately. And when we talk about the T3010, it's not just the one form, it's all those other pieces that need to be there as well that are on this slide. Financial statements, if they're not included, CRA will consider that you haven't even done the filing at all. The TF725, the second item, that's basically the backside of the labels. Many people don't even look at it and they don't fill it in, but it's important that you do look at it and return that as well. Now, second thing I'm going to mention, which is the incorrect issuance of receipts. According to CRA, when they audit registered charities, they work out that of the audited charities, 89% of them are not issuing receipts correctly. That's a very high number. And if you think that about 10% of Canadian charities do not issue receipts at all, it means just about every charity that's issuing receipts is not doing it correctly. So a few points. One is charities are not required to issue official donation receipts. So if you don't want to, don't issue them. Obviously, it's a huge benefit to issue them, but you're not required to do it. If you are going to issue receipts, however, you have to make sure you do it correctly. Some of the receipts lack required information. Some of them have improper fair market value on it. And some of them are issued when there is not even a gift under the Income Tax Act in terms of the requirements for a gift. So why would you issue a receipt at all? Obviously, it can offset federal provincial income tax. It can be very significant. Depends on the province and the type of, whether it's cash or appreciated marketable securities. But in some cases, people are getting with cash, a 50% tax benefit. And with marketable securities, because you don't have to pay the capital gains, you could be getting a 60, 70% or even more benefit. So it's a really huge benefit that a donor gets. And this is why, unfortunately, there has been some misuse of this benefit. And there has been a tremendous focus by CRA on it, both on the really big multi-$100 million issues, but also on the little issues, like making sure you have the mandatory elements. And not only can you offset up to 75% of your income this year, but if you make a big sort of gift, potentially you could offset your up to 75% of the taxes that you'd have to pay over the next 5 years. So it's a tremendous benefit for Canadians. And by the way, Canada has by far the most beneficial system for tax incentives. So just want to mention that it's something that is really a huge subsidy, and we have to take it very seriously. So do you have to issue receipts? No, you don't. But CRA suggests that if you're not going to issue receipts for certain things like, under $20 donations or whatever it is that you are deciding you're not going to issue receipts, just let people know so that they're not going to be disappointed. And by the way, if you want to make your life easy, I suggest many groups really give serious consideration to not issuing receipts for most gifting kind items. If you're giving, for example, you're being given appreciated marketable securities, shares that are on a public exchange, that's one thing. But when people are giving you toasters and artwork and other things, in many cases, you might be better off not providing a receipt. It certainly will make your life a lot simpler. And when I look at a lot of charities, those receipts amount to only a few percent in some cases of the total, but they can get you into 80% of the problems. So very important to think carefully through what you will receipt for. Have gift acceptance policies, because you don't want people basically telling you what they want and then you sort of have to just acquiesce to it because you haven't thought through these things ahead of time. Try to carefully consider, for example, what restrictions you will accept when you have gifts, and when you will give gifts. The mantra I suggest to people is, if in doubt, don't receipt. If you're not sure that it's appropriate to issue the receipt, don't issue it. Too many charities are sort of working more on the mantra of, unless we're sure it's wrong, we'll just issue the receipt. And I would highly encourage you to be careful. You don't want 5 or 10 receipts issued a few years before, when you're audited by CRA, to potentially result in you having a huge compliance issue. There are mandatory elements of the receipts. So the next 2 slides have the general mandatory elements. Make sure you have them, and I recommend to people to just put these in as the CRA suggests, to use them on your receipts, and in some cases it's a matter of just cutting and pasting and using this, as opposed to some of the receipts that some organizations have been edited for the last 20 years, and they don't look like this type of receipt and have the same information, and that can get your organization into a lot of trouble. And one recent development last summer, CRA changed the website to move from cra.gc.ca to canada.ca, and CRA is saying that by 2019, early 2019, they want all the receipts issued to reflect that new address of their website. So this is regular receipts, these 2 slides, but then if you're doing a gift in kind, there's some additional elements that may be necessary as well. And you can go to the CRA website and you can find the sample receipts. They have 4 sample receipts. And I just realized that CRA has now put a graphic there, whereas before it was text. But you can look at our receipting kit. If you type in receipting kit and our law firm, you'll find it. And you can actually get the words that are in text form if you just want to cut and paste them. But basically, I do recommend people keep it as similar to what CRA has as possible. There are many other things with receipting. If you look at the receipting kit, it's about 200 pages long, and you might find it's a good resource. You can search through it by keywords if you're interested in something like auctions or marketable securities or whatever. Okay, and so that's receipting. Many charities not doing it correctly, and it is important. The third issue I'm going to tackle today as a top compliance issue is acting outside your legal objects. Every charity to be registered as a charity has to have legal objects. These will be in your constating documents. They'll be in the trust deed, they'll be in your letters patent or articles of incorporation or constitution, something like that. So you should look at them. Are they up to date? Are they relevant to what you're still doing? Are they broad enough? If you have narrow objects that can impede the work of your charity, because you're not supposed to do stuff that are outside your object. I've seen many large donations not going to an entity because it can cover most of what they're supposed to do, but not all of it. So if you obviously don't want to have objects that are too broad and vague, but you should occasionally, every year or 2, take a look and just see and compare what you're doing. If you're doing things that are outside your objects, you should cease doing it, or consider expanding the objects. And I don't likely tell people to expand their objects or to change their objects. If you have broad objects that allow you to do what you want to do, maybe it's not worded perfectly, whatever, it might be just fine. You're not looking necessarily to raise your profile with CRA unnecessarily. But on the other hand, if you have objects which say you can only do activities in Saskatchewan, but you really want to do things in Alberta, then you need to go and think about it. Now, the main thing is, unfortunately, we have about a 1-year delay right now in CRA reviewing objects. So if you're thinking that you want to do something in the future, sometimes it's a good idea to get permission, even if it might be that you only do it in 5 years' time. But you don't want to be ready, gung-ho, have the money to do something, and then have to wait a very long time for CRA to approve the changes. And what is now a 1-year wait, with many changes we'll talk about, including with Ontario corporations, with BC corporations and others, there's going to be a huge number of organizations having to deal with CRA, and I worry that the wait on things like objects will go to become 2 years. So very important that you deal with it if it's an important point for your organization. Here are just some examples of what objects can look like. And in terms of if you want to ever change your objects, keep in mind that you can't just send new objects to CRA. You need to send a detailed statement of activities under each object. It's not like a charity application, which involves many, many different issues. It's just one issue. It's objects and activities. but I'm just saying that if you are going to go to CRA, you want to do it properly, carefully. You don't want to send them something that is clearly inappropriate, because it may bring some scrutiny on you that is unnecessary. So not a bad idea to get help from people who know a lot about the CRA processes and charity law. You can read, CRA has a guidance that they put out a few years ago on purposes, which basically sets out the way they want the purposes done. But keep in mind that there are different requirements for each of the heads of charity, and essentially you want to try and frame what you're doing in those with those requirements in mind. So that is on making sure your objects are broad enough. Another thing is gifts to non-qualified donees. Well, you're not allowed to make gifts to non-qualified donees. A non-qualified donee is a group that's not able to issue official donation receipts. Qualified donees are other groups that can issue official donation receipts. So an example of qualified donees are charities. So how can a charity do its work? It can do it in a couple of ways. A charity can make a gift to another registered charity. That's one way that they can do it. And that is something that we usually associate with foundations. But in fact, about 25 to 30,000 Canadian charities are making gifts to other charities, and that's very common. The second way that you can carry on activities is through using either your own employees or volunteers, which is the most common way of doing things, or you can work with other groups, they call them intermediaries, who are not qualified donees, either in Canada or abroad, to do the work, but you need to have direction and control over the funds and the resources if you're going to work with a non-qualified donee. So an example is if you're concerned about an issue like the environment in northern Alberta, it might be that there's a group there that is a non-profit, not a registered charity, but just a non-profit, and they are the best to do the project. You may want to hire them to do the work, and then this is called working with non-qualified donees, who are these intermediaries. But you're not allowed to just give them money and act as a conduit, that sort of thing. So if you look at it as a chart here, you have the Canadian Registered Charity at the top that can make gifts to only qualified donees, like Canadian Registered Charities or the UN or certain prescribed universities or Canadian municipalities, things like that. That's easy to do, relatively speaking. And then on the right-hand side, they can do their own activities with their employees or volunteers, or work through some type of partnership with an intermediary. Okay, and so very important is this distinction between qualified donees and non-qualified donees. Essentially, qualified donees, it's like a club. There's a number of different groups, and I'll quickly just go through them so you know it's more than just registered charities. And then non-qualified donees are 99% of the world, individuals, companies, for-profit companies, celebrities, etc., that are not able to issue official donation receipts. So in terms of the qualified donees, registered charities are definitely the biggest one at 86,000, but there's also RCAAs, these registered Canadian amateur athletic associations like the Olympic level organizations, and there's over 100 of those. There's some listed housing corporations. All Canadian municipalities are qualified donees, and by the way, if you want to improve a park in your city, or if you want to improve the water quality in an area, often a municipality is a great organization to work with. Donors can give them money directly and get a receipt, but also foundations and charities can give them money easily as gifts. There's also this listed municipal or public body performing a function of government in Canada, which is a very interesting type of category, which largely has 350 Aboriginal bands on it. So if you want to do work with any of these Aboriginal bands, depending on obviously what your objects are, it might be very easy for you to make a gift to those entities. There's, and this was discussed in the budget, federal budget 2018, listed universities outside of Canada, and there's about 600 foreign universities that Canadians can either donate to directly and get a tax receipt, or that Canadian charities can provide funds to easily as gifts. We only have 100 universities or so in Canada, and you have about 600 of these listed foreign universities. So if you've studied at a foreign university, or you want to do work, or you want to have that university do research on a particular issue, this can be very helpful. And then there's usually one or two groups on this listed charitable organization outside of Canada, so that's not that exciting. As well, the Government of Canada and the provinces are also qualified donees. So if you ever wanted to partner with them and give them money, usually more likely they'll be giving you money, but if you did want to give them money, it's easy. And then the United Nations and its agency, which includes quite a few agencies, is another group of qualified donees that you can make gifts to. So the moral of the story is you can work with a lot of groups that are qualified donees, all those categories we mentioned, but if they're not on one of those categories or groups, then they're a non-qualified donee. These are the groups that can't issue official donation receipts. Foreign charities, Canadian non-profits with no charitable status, businesses, politicians, celebrities, etc. And with those, you need to have what they call direction and control. And if you don't, and you just allow money to come in so you can issue a receipt and you hand it off to one of those non-qualified donees, you're going to be considered a conduit. You can have penalties, you can have suspensions, you can have your revocation of your charitable status. There's a lot of things that can happen that'll be very negative if you are acting as a conduit and not complying with the rules. And simply, whether you're doing a foreign activity or you're working with one of these groups in Canada, there's 8 things you need to do. You need to do some due diligence to make sure that the intermediary is a legitimate organization that has the capacity to do the work. You need to have a written agreement, and we've provided on our Global Philanthropy site an example of a written agreement for a foreign activity, a small foreign activity that meets sort of the CRA types of requirements as a basis, but it's not just any written agreement. There needs to be one that has a whole bunch of elements in it. There needs to be a detailed description of the activities. You can't just say we're giving $1 million to this group to, help poor people in Manitoba. That's not good enough. A detailed description of what's supposed to be done. And it has to be a separate activity. We can't just generally provide unrestricted funds to some nonprofit to do good work because they're good people. We need to have it clearly defined, a separate activity that they're doing for us. They're acting as our agent or contractor, doing work for us, and we need reporting on the work they're doing for us so that we know that our funds are being appropriately spent. There's monitoring and supervision. If there's changes, those need to be included. You don't give large amounts of money up front. You do periodic transfers. So you give some money, you get reporting back that shows the funds have been spent appropriately. Then you give more money, you get more reporting, etc., etc. And then you need to have books and records in Canada showing that you are doing these things. And if you want to look, CRA's guidance is in 2 places. They're almost identical, the guidances. One is for charities carrying out activities outside of Canada, and the other one is for using an intermediary to carry out a charity's activity within Canada. Largely similar to those guidances. So that's on dealing with non-charities, being careful that you don't get into trouble, that you're being viewed as a conduit. Now I'm going to talk about employment issues. The charity sector has millions of employees, and in fact, most money that the charity sector is spending is on human resources, on salaries and benefits and things related to that. So very important that Canadian charities are carefully monitoring this issue. One of the biggest issues, which is similar to a business context, is calling someone an independent contractor when really they're an employee. And there's many negatives that can come out of it, including that you wouldn't be doing source deductions and your directors can be on the hook for the amounts that are owed, etc. There's many different consequences that could be problematic. But the basic idea is with employees, you need to withhold source deductions and then remit them to the necessary groups like CRA. And very important that, in fact, this is done. If you're not done, this is probably the #1 reason why a director of a Canadian registered charity would actually be on the hook and have to pay out money. So directors and others should be mindful of this and should be reported on that, in fact, these deductions are being made, that CRA is receiving the remittances, for example, that sort of thing. That's a very important issue. Then also, just because it's so important, these relationships and the amounts of money can be so important, so large, it's important to have proper employment agreements. They have to deal with a number of elements, but obviously, what happens if the relationship sours and there needs to be a termination? You want to know ahead of time what the deal is, and it needs to be a legally enforceable provision. And many charities, although they have employment agreements, what they have are not legally enforceable, so it's a problem. You obviously can't provide excessive compensation to an individual at a charity. Also, keep in mind the flip side. There are people who are in some cases earning less than minimum wage for employees, and that is also not allowed unless there's some exception to the minimum wage legislation. So many charities are making mistakes on, in some cases, both ends. Okay, they're paying some people too little, and they're paying some people too much. So watch those issues as well. Another top sort of compliance issue, and sometimes CRA will revoke a charity just for this, because when they come in to do an audit, they're not really doing a forensic investigation. If you don't have good books and records, if they can't really work out what has happened with your charity, they don't have to put it all together. This alone is enough for them to be able to revoke the organization. So you're supposed to keep adequate books and records. I say that's not a very high standard, but it is adequate books and records, preferably in either English or French, but they don't have to be. And it needs to be able to show the revenues, including charitable donation received, verify resources spent on charitable programs, so that relates to financial management and your system and internal controls, and also verify that the purpose and activities continue to be charitable, which then covers a huge number of other areas. So this may seem like it's quite narrow, but in fact, they're expecting that not only are you going to be doing a lot of good work, but you're going to have books and records that'll show that you are doing that good work. To be frank, I never understood how it's possible to run a good charity without having good books and records. Obviously, it helps with a charity audit if you have good books and records, because you don't want to have, for example, suspension of your receiving privileges or revocation because of it. You know, but it tells you where your expenses go, your revenues come from. If you didn't have that information, it's really hard to do other things like issuing official donation receipts if you don't know how much people gave you. And also for the board to decide, is it allocating adequate resources to different areas? So that helps with decision making. It's very difficult to fill in the T3010 if you don't have complete records. And you want to have information not only your current situation, but your past financial position, so that you understand where you're coming from and going to. And many stakeholders may require it as well. In terms of books and records, it's not just it's basically a combination of different things, but there's a governing documents. Here are listed a few things. It includes financial records. In some cases, it'll include source documents like invoices and bank deposit slips and things like that. So books and records, it cuts across all areas. If you don't have good books and records, it's really hard to comply with the requirements to the Income Tax Act. Now I'm going to talk about business activities by charities and how they're allowed to do certain business activities, but they're not allowed to do what are called unrelated business activities. And increasingly, they're talking about doing things like social enterprise, etc. It's very important that they think carefully about the rules that relate to charities and business activities and whether they're allowed to do something. So, for example, charitable organizations and public foundations are permitted to engage in related business activities, but private foundations are not allowed to engage in any business activities. So you have to work out what type of registered charity are you. Also, is it carrying on business? So if an activity is being done, is it a business activity and is it carrying on business? So is it commercial in nature, where you're deriving revenue and providing goods and services with the intention to earn a profit? And is it continuous? So as an example, if you were to do a bake sale once a year, and your intention is to make a profit off it, you would probably be considered to be a fundraising activity and not a business activity because it's not continuous. But on the other hand, if you had a bakery, say in a hospital, and you're doing it all the time and trying to make money, then that would in that case be considered to be a business activity. So this is important to keep in mind because charities get money from a lot of things, not just business activities. They can get money from charitable activities, from fundraising activities, even from investments and other things like that. But first point I would make on business activities is that, and I hear this a lot from charities, why can't charities just do whatever they want when it comes to business? Because in the end, if they make a lot of money, it's just going to get spent on wonderful projects. So why is finance and CRA and politicians getting in the way, restraining charities in this area? And there are a number of sort of reasons for it. One is that, if you think of a company like Bell or Rogers, there aren't really charities competing with them. But the charities that are competing generally are more businesses, it's restaurants, photocopy shops, things like that. And quite frankly, the small businesses are very worried about that competition by groups that don't have to pay taxes in many cases, et cetera, et cetera. So there's a concern about unfair competition with private business. Business is not a charitable object, although it's good if some charitable organizations are doing business activities. It can be very positive, can achieve a number of objectives, but business is not unto itself a charitable objective. And so we're not looking to have all the charities spending 80 to 90% of their time running businesses. It's also going to encourage, if you had no restrictions on business activities, it'll encourage businesses to set up as registered charities. They would be tax-free at the end of the year and have additional benefits, but that's not what we're trying to do. And if we were to make it easy for businesses to avoid paying taxes, it just means individuals have to pay more taxes. Also, in other countries, they allow more scope and leeway for groups like charities to do business activities, but they tax it. So, in fact, I think we just have to be careful because there's a lot of charities bringing in a lot of money, which isn't taxed, and it's part of this, related business activities. If one changes the rules, you may end up with many charities actually being far worse off than they are right now. So be careful what one asks for. Because it might be that charities will be given more leeway to do business activities, but in the end, it might be that they become taxable just like businesses, and many charities in that case are going to have billions and billions of dollars that they're going to be providing in taxes, which will not be something that's necessarily good for the charity sector. There are two kinds of related businesses that a registered charity can conduct, and I'll start with the second one because it's the easiest. Businesses that are run substantially, 90% or more, by volunteers. For example, you might have a small coffee shop in a hospital run by volunteers. So this is great. You can do just about any business activity through having all volunteers doing it. However, in most businesses, you need to have consistency, and you might need to have paid staff people and specialist support and things like that. So that sort of number two doesn't work with every scenario. So you can do a regular, quote unquote, what we'd call business activity, like have a restaurant. Let's take the hospital example again, but it has to be linked to the charity's purposes and subordinate to that purpose. So what that means is the restaurant isn't on the other side of the city. The restaurant is in the hospital, and we want patients and the medical personnel and others to be able to eat food while they're at the hospital, so they don't have to go far away. So it's linked to a charity's purpose, and it's subordinate because you've got a $500 million hospital and maybe it's a $500,000 restaurant. It's tiny in comparison. But if you had, for example, a parking lot, let's take that example, it's next to the hospital, it's linked, and it brings in $20 million a year. It's subordinate because the hospital is $500 million. But what happens if we took another example? It's not a hospital, but it's a healthcare clinic with one doctor that has a revenue of $500,000. And next door it has a parking lot taking in $20 million. That is not going to be a subordinate activity, therefore it's not permissible. So there are many, many activities that charities can take on, but there's also others that they can't do, or they can't do it at a certain scale. But it's not that complicated because they can always spin it off. Worst comes to worst, they put it in a for-profit corporation, they pay taxes. If they were to donate, for example, the funds to a registered charity, they can offset up to 75% of the taxes, which is pretty significant. So lots that can be done. Charities basically can do just about anything. It's just a matter of structure. They can't necessarily do it within their own charity. Private foundations can't do any business activities, but the charitable organizations and the public foundations can do quite a bit inside, but there are limits, and sometimes you have to set up structures to allow for the activity to be done elsewhere. And if you want to read more about it, CRA has a guidance called What is a Related Business? They also have another guidance on community economic development that you might find helpful. And, there can be penalties, etc., and could be something that you can get into a lot of trouble on. My main concern with businesses is, number one, they say 9 out of 10 small businesses fail. So, in fact, many charities will start a business and it actually is going to be sucking away a lot of resources, time, effort, and money It isn't going to be this, sort of like a mint and just, printing money and it's so successful. That's my biggest concern, basically when it comes to business activities by charities. And in fact, because some of the financial management done within the charity isn't so good, there are many charities that think that they actually have a very profitable business. But it's only profitable because they're not fully taking into account the real costs that the charity is subsidizing the business. And by the way, you can have a business that is, not even making money, and it could be worthwhile for a charity to do it because there could be many other things that are important. It's not just about the profit side of running a business. It could be a very positive thing having a particular business activity going on. But it's always good to know, is it actually bringing in money, losing money, that sort of thing, and many charities are probably losing more from business activities than they realize. The 8th point I'm going to cover is approximately 1% of charities, about 800 a year, are going to get a communication from CRA. They'll get a letter, for example, saying that CRA wants to come and audit them. This is something that is very important, that if you're going to be audited by CRA, that you understand the process and you deal with it properly. Charities have to assist with the audit. It's CRA's responsibility to audit charities, and charities have to assist. And I'm talking here about a charity audit, not like a GST, HST, or EI audit or something like that. And like I said, there's about 800 of these audits a year. Some years, and increasingly, they've been looking at bigger organizations, going after much bigger organizations. So in fact, the number of audits dropped then because these are more complicated, cumbersome audits. But they try to strive for about 800 a year. 600 are field audits where they actually go to the charity and meet with the charity and get documents and talk to the charity. And 200 are office audits where they're largely sending out a questionnaire and letters asking for material and then looking at it at the office. How are charities picked for audit? I will tell you that random selection is increasingly not being used. The methods of selecting charities are becoming more and more sophisticated, and less is about random selection. It could be a complaint about the charity from the public, but I will tell you that many complaints by the public are frivolous or not well-intentioned, let's just say, and CRA is definitely not picking up and auditing every group because someone from the public complains about something. We know that I have many clients who have had long letters written about them because they're involved in certain areas that are controversial. It doesn't mean that you get audited because someone complains. But you're more likely to be on the radar, let's just say. If there's a red flag from a T3010 filing, that's probably the most common reason that a charity will be picked up, and another reason why you should be careful to think about your T3010 to make sure it's filed accurately and on time. If you're involved with an abusive tax shelter or charity receipting fraud, it's almost guaranteed you'll be audited and CRA will be setting aside any of the receipts, etc., etc. Sometimes it's follow up on a previous audit or a compliance issue. If you're on a board, make sure you check, is there a compliance agreement involving the organization? Because sometimes a compliance agreement might have been signed 10 years before and no one asks, and the board's not even aware there's a compliance agreement they're supposed to be complying with. And if you do have a compliance agreement, 2 to 5 or 10 years later, CRA will be coming back. And if you're not doing exactly what you said you would in the compliance agreement, you have the tremendous possibility of either an intermediate sanction like a penalty or a suspension or revocation. And then also occasionally CRA will review a particular segment, so they'll have a targeted review to try and see what the level of compliance is in a particular area. But right now, the biggest thing CRA is doing is a risk-based assessment, and the fact is, the bigger your organization is, the greater amount of potential risk that charitable assets could be misused, that receipts could be done inappropriately, things like that. So increasingly, I'm seeing much larger organizations being audited, and it makes sense. Why audit 100 $10,000 charities when you can audit, $1 million charity and it affects the same amount of resources? And now they're auditing, $500 million, $1 billion charities. They don't care because their attitude is every charity has to comply with these rules. And what are they auditing? They're looking for financial information, but they're also looking for other information such as contracts, governing documents. If you do foreign activities, the contract agreements you have with foreign non-qualified donees, things like that. There are approach is what they call education first, which means that in the case of very serious non-compliance, like fraud or abusive charity gifting tax schemes, or if you're not cooperative, they basically will try to educate, explain to the charity what's right, those sort of things. What are some of the most common things they're finding? Improper inflated receipts, undue private benefits to people involved with the charity, foreign activities that lack direction and control. If you're doing any foreign activities, you need to pay attention to the rules that we talked about earlier. Gifting to non-qualified donees, so this is also within the Canadian context. It's things like lending your registration to a non-profit group that can't issue receipts and having the money flow through your group to them. Inadequate books and records, just some groups that aren't spending that much on charitable activities and they're spending money on other things. Participation in a registered or unregistered tax shelter. Those are some of the biggest concerns. And in terms of what comes out of these audits, clean audits, not that many are getting that. Educational letter saying that there's some issues that you should fix is the biggest number. Compliance agreements is creeping up, becoming more and more common, and those you really have to watch out because it essentially means that when they come back, if you haven't really done it right, you're going to have a lot of problems. Some of these end with the charity voluntarily revoking or an annulment. And then, for example, in that 1 year period, there were 39 notices of intent to revoke, which is higher than normal, but it really depends on the year, because usually it's more between 20 and 30. And penalties and sanctions are going to be jumping up tremendously because CRA is focusing in on that quite a bit. So just some quick tips. If you do get called or you get a note from CRA, a letter saying that they're going to be auditing you, respond quickly. They usually want to set up a time. They usually will give you a few weeks to find the time that's appropriate. They realize many groups it's volunteers that they have to deal with. And use the time that you have before CRA comes to make sure your files are more up to date and things like that. Be cooperative and polite. I feel like this is sort of what you would learn in kindergarten. Use your time wisely before the audit. You can't create and backdate things, but you can, if there are problems, you can fix them, and so that then CRA knows that it wasn't done properly 2 years ago, but now you're doing it properly. They're much more likely to not consider it as important as if they have to discover it, and then you will fix it because they're telling you to fix it. Choose carefully which charity officer represents the charity. If they have a significant dislike for CRA, they probably are not the best representative. You don't need to have a lawyer, certainly not in the meetings and things like that, but it is a good idea if you're going to be audited to have someone who's very knowledgeable about CRA and charity compliance reviewing some of the most common issues, like your receipts, like your T3010 filings, to see if there are things that can be looked at and if better systems can be put in place. And in some cases, very quickly, better systems can be put in place, which may mean instead of a compliance agreement, you just get an educational letter or something like that. Make your records up to date, and so you'll need to be able to provide material to CRA. So it's good to have your filing system working well. Answer questions at the audit truthfully and only if you know the answer. There's nothing wrong, especially with more complicated organizations, to say, I don't know, but I'll get back to you on it. Don't just dump documents on CRA because they may actually read everything and find lots of problems that they wouldn't have even been looking for. So best is if they ask for a document, provide it, unless there's solicitor-client privilege on it, that sort of thing. Provide copies, don't provide originals to CRA because things can get lost in the shuffle as well. It can take them a year or two to finalize the audit, in some cases even longer. So you don't want your original documents leaving. And then while you're having the discussion with CRA, very important to take notes, understand what CRA is saying. They're not always getting it 100% right. That's okay. But if they're raising a concern, be aware of it. You can discuss it with your lawyer. Is it something you should change, fix, etc.? But definitely don't get into arguments with CRA. If they're saying something's wrong, most of the time they're right about it. But if you can make some changes and fix things up if once you've discussed it, for example, with a lawyer, you work out, no, you're actually doing it wrong, then you know what? You don't want to wait a year or two for CRA in some cases to get back to you. You want to fix the problem immediately. Now, I'm going to go on to the 9th point here, which is on corporate changes. There are some very big corporate changes coming down the line. In BC, all of the BC societies by November have to make changes, otherwise they're going to get dissolved. In Ontario, we're going to have probably the Ontario Nonprofit Corporations Act, ONCA, coming in a couple of years. And so a lot of things going on here that will affect a lot of organizations. And the first thing is know what you are. So for example, if you are under the old Canada Corporations Act, you should now be under the new Canada Not-for-Profit Corporations Act. All of the old CCA corporations have been dissolved. So in fact, thousands and thousands of charities and nonprofits have been dissolved. And if you're dissolved, by the way, CRA eventually is going to get around to taking away your charitable status. So also, when you made the changes and moved over to the CNCA, if you're a registered charity, did you let CRA know about those changes? Okay, so that's on the federal side, and I'll tell you many organizations can do a better job of working out the system for federal filings to make sure that they're getting their filings in properly. And then ONCA is going to affect about 20,000 charities, probably another 15,000 nonprofits. They're going to have to make changes because of this new act coming in, which is targeted for 2020. As well, there were a lot of changes to the current Ontario Corporations Act a few months ago, which allow Ontario corporations more flexibility than they had before. So for many Ontario corporations, they may want to look at what does the new rules provide, what will the future rules provide, how should one deal with it. And for some, the answer will be to do nothing, to wait for ONCA to come into force, and then to do certain things. But for other groups, that is probably not the best strategy. They may need to make changes because they might have been waiting for like 10 years now to make the changes. And they may need to make those changes. And then later, they can make further changes under ONCA. For other groups, and we've done many of these, basically Ontario Corps and Manitoba and Alberta and others, basically moving out of their provincial jurisdiction and moving over to federal jurisdiction can be, for some organizations, a very good way of skipping some of the changes that are happening provincially. And generally speaking, I tell people don't set up organizations if you can avoid it provincially. It's often much easier, especially in a place like Ontario, to set up a federal corporation rather than an Ontario corporation and have to redo everything. So if you're thinking of moving from Ontario to federal, if you're an Ontario corporation, there's many reasons to do it, and we've written a number of articles on this, but you can basically avoid the problem of what might become a multi-year wait and a lot of uncertainty around the introduction of ONCA. It means you won't have to have public guardian and trustee approval for future corporate changes and things like that. So all in all, there's a lot of advantages, but there are a few groups that it isn't a good idea to move forward. So that's on the corporate side. Another thing is gift restrictions, and very simply, I'm saying that when you, as a charity, you're prepared to accept a gift with certain restrictions on it, it's really important that you comply with those restrictions. And what that means is if you've committed that, for example, it's only going to be spent to help homeless people in a particular area, that in fact you do it. And it's very important that you realize that in some cases, the world is changing quickly. Things that you thought you could do, you can't do. You should always try to have an ability to make a change to the restriction. And if it's an individual donor, it's one thing. And if you're asking the public for money, it's another thing. But if you don't have that ability, you might have money that you actually can't spend, or you have to go to court, and it's very cumbersome, and the court may not agree to allow you to make changes. The biggest myth out there is that if you have a restricted gift, say a donor gave you $1 million for scholarships, but there's nothing that allows for an amendment in the agreement, the myth is that the charity and the donor can mutually agree to make changes after the gift is made. And there's a couple of recent BC cases which say that, no, you can't change it, and the courts are not going to help you in this case. So before you deal with restricted gifts, before you deal with a fundraising campaign to raise $10 million for something, really make sure you've got your language, your gift agreement, your public solicitation information carefully thought through to give you the necessary flexibility that you need. And restrictions is not only time and, is it an endowment and or is it that it can only be spent 20% a year or whatever, but also as to the subject matter of the expenditures. So whether it's on homelessness or whether it's on healthcare or whatever, and both of those restrictions need to be respected. Another, I'm just going to skip through this here for a second, but the problem with restricted gifts is often that the donor is trying to do what they think is the best. The organization is trying to do also what they think is the best. And in many cases, there's very limited ability to predict the future. So maintaining quite a bit of leeway and flexibility actually can make money far more useful than if it's narrowly restricted. And for some groups that have a lot of restricted gifts, it can actually undermine the whole organization, and that could be really problematic. So some ideas of preventing problems with restrictions are, in some cases, you might have to refuse the restrictions, but you could lose the gift. But if it's ones that will be very problematic, those restrictions, you might be better off to just to lose the gift. Try to make them as broad and compatible with the areas of greatest need that you have. That would be probably the best thing if you have to go along with the restriction. Ensure that there's clear communication with the donor. Have the necessary caveats and provisions either in the agreements or in your emails back and forth or in your public communication to maintain as much flexibility as possible. And what I'm going to do is I'm just going to cover up a few recent developments that happened. One of them is we obtained a document from CRA, 68 CRA reasons for denying your Canadian registered charity application. You might want to take a look at it, even if you're an operating charity and not planning on applying for anything with CRA. It gives you lots of ideas of the sorts of things that CRA, when it looks at a new organization, could say they're concerned with. The other one is CRA clarified last year that with Aboriginal bands that want to become qualified donees under that category, municipal or public bodies performing a function of government, that in fact it's a very simple process. And if you happen to know Aboriginal bands that are not on the list, encourage them to think about getting on the list. Another thing is that we recently obtained a copy of CRA's draft guidance, Advancement of Religion. It's been circulated within CRA for about 10 years. Recently, as of about 5 years ago, it was essentially CRA started using it, and it has not been published, and we don't know when it's going to be published by CRA. It's become a bit of a political football. But the moral of the story is you can find the whole draft guidance on our website. We managed to get it through an access to information and privacy. So if your group deals with religion in any way, you might find that as a helpful document. As well, CRA has updated their community economic development activities guidance in the last few months, especially to dealing with disasters and the extent to which in a disaster you can help certain groups like businesses and things like that. I mentioned the BC societies. I'm just going to mention it again because it's so important. But if you're a BC society, if you haven't made a transition by November, that could be very negative for your organization. CRA has moved their website, so you need to update your charity receipts that you're issuing and things like that. Something else I mentioned is the issue of CRA is increasingly auditing large and complicated organizations. And it isn't bliss anymore to be a large registered charity thinking that, oh, they'll never come to us. We're too big to fail. We're too important. They don't care. Their attitude is all groups have to be following the rules. CRA is increasingly looking at internal controls of registered charities. They don't say anything about it really on their website. We have a whole bunch of information from both the CRA and from other regulators on what sort of internal controls would be expected. Another thing is that these abusive charity gifting tax schemes that I mentioned earlier, there have been a large number of lawsuits over them, and a number of professional advisor firms recently were sued for over $800 million for their involvement with one of the schemes called GLGI. So I encourage charities, and I have for a long time, stay away from these schemes. On a much more positive note, the Senate has put a special committee together to look at the charitable sector, look at laws and policies and how it impacts the charitable sector, and there might be some interesting discussions that come out of it. On a less optimistic note, in the United States, there's been tremendous changes that have happened there, and one of the changes is now 19 out of 20 Americans, practically speaking, when they donate to charity, are not getting any tax incentive. So what that means is because of the high numbers that you need in terms of either gifts or other deductions that you can make, and for a couple, the number is over 24,000 in the US. It means that, like I said, 19 out of 20 Americans will probably not get a tax benefit. This, unfortunately, from this bad news comes some good news for Canadian charities, which is for 19 out of 20 Americans, when they donate to American charity or they donate to a Canadian charity, they get the same tax benefit. In other words, no tax benefit. So, in fact, many Americans who support you, they may be more inclined to give you money now because with this change, they aren't going to probably be getting a tax incentive anyway, which is unfortunate, but that is one of the negatives that have happened in the US. Another thing is in November 2018, all new charity applications will have to go through the new electronic system that CRA has called CHAMP. and you will have the option, if you want, of filing your T3010, but it's not mandatory. You can file it as of November 2018 on the CHAMP system, and many charities should think about setting up a business account with CRA if they don't already have it, and may want to try that out. It may make it very helpful in the future, make it easier to file your T3010. Anyway, those were some of the points that I wanted to raise today, some of the recent developments as well as the top compliance issues. And Marina, thank you very much for this opportunity, and if there are any questions, I'm happy to answer them.
Wonderful. Thank you, Mark. Yeah, we do have time for just a few questions. We're conscious of being a little over time today, but if anyone does need to drop off the call, we are recording the Q&A, so you can always review that when you get the recording tomorrow. So let's kick things off, Mark, with the T3010. How do you know what the date is that you have to return it?
That's a great question. So it's 6 months after your fiscal year end. CRA has a nice infographic if you're challenged when it comes to counting, like I am, which basically, for example, would say that if you have a December 31st year end, then it has an arrow that points to the end of June is when you would be filing it, etc. So 6 months after your fiscal year end, and check out CRA's infographic for the T3010 filing to remind yourself of what the date is. And try not to wait till the last week. Get it in a month or two before if you can.
And just to confirm, you did say that existing charities will be able to use the new CHAMP system to file that as of November 2018, correct?
Yes, existing charities can file using the new system, but they're not having to file. They don't have to. It's not mandatory. Maybe in a few years' time, once we see how good it is and how easy it is and how it saves CRA a lot of money, they may move over, many years from now to making it mandatory. But for now, you can continue filing it manually, you can continue doing the normal things you're doing, or you can use the new system in November. I'm guessing, I'm looking in the US example, about 60% of the groups are filing electronically. And they're, so it's become, and in fact, they're looking at a law being passed in the US to make it mandatory that every group has to file electronically in the US. So, eventually this is the way we're heading. It's once a year, it needs to be filed, so it shouldn't be too big a problem. But for now, it's status quo. You can't file electronically. As of November 2018, you will have the option if you wish to.
Wonderful. And I see we're getting a number of questions asking about your slide deck, Mark. There's so many good resources there, and I just want to confirm with everyone that we will send a PDF to the slide deck as well, so that you'll have all of those available to you. Okay, moving on to tax receipts. Do you have some examples of top info that's generally missing from tax receipts?
Oh yeah, well, okay, so you have a whole bunch of elements that need to be on the tax receipt. The most common ones are typically things like it doesn't have the CRA's website on it, or it doesn't have the business number of the charity on it, or for that matter, it's the wrong business number. Some groups, they actually copy another group's tax receipts because they don't know how to do it themselves, but they forget to change the BN number. I mean, I've seen all sorts of craziness looking at this stuff for 20 years. Some of the more common mistakes are you're supposed to have the serial number that you have on a receipt is supposed to be in sequential order. So some groups, they just come up with a random serial number, and that's not sequential order. There are groups that even their name is not correct because it's some name that they're using, a business name, but it's not the name that they have with CRA. So that would be another example of a problem. Just many, many different issues. There's things that people put in receipts that shouldn't be on receipts, and there's mandatory elements that have to be there that are not there. So both of those can create issues. About the only thing you should have on a receipt that is not one of the mandatory elements is your logo, if you have a logo. Other than that, nothing should be on the receipt. If you want to do a letter to the person or something, keep that separate, maybe the top of the page, and then keep the receipt down at the bottom. But yes, I've seen receipts with every element basically missing. And now with the changes since 2002, where it's talking about the eligible amount of the receipt as opposed to just the amount of the gift, you have more information that you need to basically put on the receipt.
Great. And can you speak to any CRA rules that are around digital record keeping for charities?
Yeah. So CRA has somewhat embraced, but not fully digital and online and in the cloud and all this sort of stuff. But basically, so for example, with receipts, you can have electronic copies of these receipts, but they should be the same electronic copy of what was sent out, and it has to be printable, for example. So it has to be accessible. If you have it in some sort of format on some proprietary system and it cannot be printed later because you don't have access to the system, then that would be a problem. So make sure that if you have copies, for example, electronic copies of receipts, that you keep them as long as you need them, that they are printable, that they are accessible many years later. So for example, a PDF format might work well, things like that. But you can definitely have electronic copies things, and that is helpful, but they need to be in Canada. So for example, you can't just have it maybe electronically in another country that is not yet accepted by CRA. The other thing is that with something like if you do receipts electronically, let's say you use a Word file or you use an Excel spreadsheet, CRA would ask that you burn a copy of the actual document every now and again, so you have an unalterable copy of it. Because as you know, an Excel spreadsheet can be adjusted and changed, and you know, they want to be able to come in when they do an audit and know that, you know, 3 years ago, this is what the spreadsheet said, because obviously people can easily change it and it's difficult to follow up. So they say when it comes to receipting, to have a burned copy of it if you're using something simple like an Excel spreadsheet to prepare your receipts. Okay.
Good stuff. And I think this will be our last question for the day. And I know that we're not covering employment law today, but with regards to what the CRA is looking at, are there good strategies to avoid the issues around independent contractor versus employee? Are there, you know, certain action items that should be included just to avoid that blurring of the lines?
Yeah, I mean, it's obviously very factually dependent on the situation, but I would just make a few high-level comments. One is that if in doubt, you're better off almost always making the person an employee rather than an independent contractor. And what happens is usually it starts off innocently enough. You're hiring a person to work for the organization for 5 hours a month, but they're really good, and you end up having them working 50 hours a week. And you know, at some point, they no longer were that independent person coming in and just doing a very unique, distinct task, but now they're becoming something much more integrated in the organization and an employee. But basically, there's a few issues. One is that, you know, when I say rather err on the side of making people employees, it's the issue of paying taxes. And if you take off the tax and remit it directly, you've got less potential risk and liability. So I see too many groups trying hard to make someone an independent contractor. As well, you get a lot of benefits when you're an employee, including EI, maternity benefits, things like that. And you're not doing a person a favor by paying them X amount of money as a contractor when in fact they'd be better off you paid them that as a salary, et cetera, et cetera. So there's many things to keep in mind, but I would just say that, you know, one needs to carefully think about it. Also keep in mind that what is paid you know, to employees will be on the T3010 reflected in there, so you need to make sure that all that information flows through when you're doing that. But, you know, CRA has some great information on their website where they set out the types of factors that they would look at. It largely comes down to control. Is this a plumber coming in with specialized expertise? You don't know anything about plumbing. They're going to fix the problem. They're going to leave, that sort of thing. Or is it, you know, someone, for example, at an organization who is at the front desk, the receptionist? You know, these are very different scenarios. And like I said, if in doubt, you can also go to CRA and ask them for a view as to what the answer is. But in most cases, it's better off for the charity and the individual sometimes to rather just consider them an employee and, you know, have good employment agreements, also have good risk management to make sure that you are hiring the right people, that you're supervising them appropriately. You're making sure that if there's any bullies or people doing bad things in the organization, that you get rid of those people. Whether it's volunteers, employees, independent contractors, etc. You don't want people around who are going to create potential liabilities, destroy the reputation of your organization, and hurt people, that sort of thing. Okay?
Wonderful. Well, thank you again, Mark. This has been a fantastic presentation. We're always happy to have you back speaking for us. So thank you again for today.
Thank you very much, Marina. I really appreciate it.
And just before we sign off, I want to remind everyone that we are to follow up with you by email tomorrow with the webinar recording. There will also be a short survey that will take less than 5 minutes to fill out. We hope that you'll complete that for us if you can. You'll have an opportunity there to also let us know if there are other topics you'd like to see covered in a future session. And we are kicking off our free Day in the Life series of webinars on May 17th. We're going to have Leanne Pico discussing the importance of self-care for nonprofit professionals. So we'll have a registration link for that session in tomorrow's email as well, in case the topic is of interest to you. And with that, I want to thank you all again for joining us. I hope you all have a wonderful rest of your day. Bye-bye.